And you have to be realistic about what fits in these people's lifestyles and schedules.
What about relocation terms? I understand in New York State, there's a law that really addresses, I think they call it the best interest test that has to be satisfied. What exactly is this best interest test, and how does the court use it as a tool for addressing parenting issues?
There's a lot of areas of law where this best interest test comes into play. It has to do with custody in the first place. It has to do with a lot of things. But the idea is what's best for the child in this context. Now, relocation can be a relocation across country, or it can be relocation just a county or two away, and they have significant importance. Obviously, when the person moves a long way away, then you have to rearrange the entire parenting time schedule because you can't visit on a weekend very easily, or certainly not during the week. And you tend to do is block the time more and reduce the support because the person who is coming to visit has to live in a hotel, rent a car, eat all the meals out, etc. If the relocation's a short distance relatively, it may or may not be a big deal, but you can't put a 4-year-old on the train up to White Plains and back every Wednesday night. That just doesn't work. And I've occasionally dealt with agreements that other people, not me, had drafted where they had provisions like that, and they just don't work. New York is the hardest state to relocate into the country. You have to really show that the child is going to be better off with a move. And generally, that there's nothing comparable to what you want to move to here in New York. Good example is a case a number of years ago where a woman remarried and the husband's company moved to Dallas, and there were no comparable jobs in New York. It was American Airlines. And the court said that was a reasonable reason to move. And almost at the same time, a woman remarried someone who was signed to Paris, but didn't have to go. Now, you can't blame somebody for wanting to go live in Paris for a couple of years, but he didn't have to go. And the court can't keep her from going. The way they phrase the decision is, you can go, but leave the kid. And that's pretty much what they do. So they look at everything. Was the father always attentive and kept the visitation rights he had? Did he pay the support? Did he have a strong relationship? All those things. So if you're the father of the year after you're divorced, it's going to be very hard for your ex-spouse to relocate. If you are the father from the movies who never pays any support and the kid never sees, it's going to be much harder for you to stop that because what do you have on your side of the table?
Are parenting plans difficult to enforce, and where does an ex-spouse go? Do they keep on calling their lawyer every time there's a problem? Is there some 800 number they can call? How is all this being enforced?
Well, it works only as well as the people are rational in setting it up. When they put a lot of bells and whistles in they can't keep up with, like the guy who never comes home before work at 8 until 9 o'clock at night wanting 6 o'clock visitation, that's going to not work. Mom's going to get mad at dad for not showing up, and that's going to create more friction, not less. Enforcement of a parenting plan is a difficult thing. Now, normally what happens is that the non-primary parent is upset that he or she isn't seeing the children as much as the plan required. Then you can go to court and get a court order that directs the person to comply with the plan, or maybe even hold them in contempt if things are bad enough. You often do call your lawyer, and the lawyer doesn't really have much that they can practically do about the whole thing, especially if you call them at 5 o'clock on a Friday afternoon about Saturday morning. And that happens more times than I care to think about. I used to have much more hair before those calls. Or the kid is getting on the camp bus and somebody doesn't want them to go to camp. That's happened too to me. But you get the calls. A parenting coordinator can be very helpful if you have one appointed and agreed to it. But I must say that often it's hard to get the courts to enforce these things if you're the non-custodial parent. It takes some effort, and they tend to give the benefit of the doubt for a while. But I've also seen many cases where interfering with the other parent's time with the child has caused a change in custody, because our highest court has said that failing to promote the relationship with the child with the other parent is per se bad parenting.
Do these parenting plans have clauses for tragedies that may happen at some point in time?
Yeah,
whether it be a death of a family member or a sibling or a grandparent or whatever like that?
Most don't. I kind of believe in it. Having been raised by a stepmother because my mother died when I was very little, I believe very strongly in this stuff. And generally speaking, in New York, these other relatives don't have much in the way of visitation rights if something happens to their own child. So if dad dies, dad's parents have some limited visitation rights by statute, but his siblings, The kids' aunts and uncles, their first cousins have none. So I like to suggest to people that they list a couple or three people who at least get by the first hurdle in getting the rights. They have a right to go to court and show that it's in the best interest of the child. So normally it's a two-step process. Do I have a relationship, and then is it in the best interest? So you get by the first one. I find it's not hard to negotiate those because nobody knows which side is going to get gored because none of us know who's going to die first. A harder thing is when you're negotiating and you're representing a step-parent who has a strong relationship with the child. They don't have any legal rights at all to visitation. And therefore, you have to hope that the biological parent realizes the importance of that psychological bonding. There is a slow, and I say slow, progression toward the court starting to recognize that psychological parenting counts. And I hope, and if we have this conversation in 10 years from now, that I can say categorically that that's the standard now.
What do you feel now are the biggest obstacles you find in writing a parenting plan that is purposely equitable to both sides? Whether you're representing, I'm sure you represent both the husband in some instances and the wives in some instances. And the husband and wife, whether they be the custodial and non-custodial parent, they each have their own perspective of what's going on. What do you find to be the most critical concerns that the parents have?
One of the issues that comes up frequently if the children are very small is whether you have overnight visitations. Most people today realize that the father can diaper a child and put it to sleep safely, but I've had more than a few of these in recent years where that became an issue. That's one that I think comes up a lot. If the parents have different religions or different religiosity within the same religion, those get to be difficult because often religious matters are hard to compromise because it's a belief which you can't really change. So one of the most complicated cases I ever had was the couple were both Jewish but non-observant, and the husband got very religious somehow, and the wife didn't. And trying to accommodate this in the terms of the parenting plan was just decided impossible. In fact, we ended up having to try the case, which is a loss when you try a custody case because you don't want to do that.
Well, Lenny, I'd like to thank you for joining us today. You're certainly incredibly informed about this topic and certainly very passionate about it. Our guest today has been attorney Leonard Florescue of the law firm of Blank Rome. If you have any questions on parenting plans or any other family law issues, I'm sure Lenny will be happy to assist you. You can reach him at his New York office at 212-885-5396. As always, our audience is welcome to contact our offices with any questions or comments. Stay connected with us on the web at www.msgcpa.com, where you can also subscribe to our newsletter, Forensic Perspectives. We can also be found on LinkedIn, Facebook, Twitter, and of course by phone. Your topic suggestions for future broadcasts are always welcome. Until our next podcast, this is Mark Gottlieb. Thank you for joining us.
You have just enjoyed another episode of Forensic Perspectives, hosted by financial expert Mark Gottlieb. For questions and/or comments regarding this broadcast, please feel free to contact Mark by phone at 516-829-4936 or via email at msgcpa@msgcpa.com. We also encourage you to visit our website, www.msgcpa.com. The opinions and commentary in the preceding program provided by our host and guests are for informational and educational purposes only and may not be their personal or professional opinion. No accounting, tax, or legal advice is being provided. The information provided within this broadcast is not an invitation for an attorney-client or accountant-client relationship. One should always seek the advice of competent professionals to assist in their specific needs. In addition, this podcast will not be updated for changes in accounting practices or law. As such, one should not rely on any information provided by this podcast. References to resources are provided solely for the listener's convenience. We have not reviewed or verified any information, advertising, products, resources, or other materials mentioned herein. This broadcast is copyright of Mark S. Gottlieb, CPA PC, all rights reserved. Any redistribution or reproduction of part or all of this broadcast is strictly prohibited unless authorized in writing.